Lordship, may kindly allow me to make a mention for item number 14, madam.
Yes.
Item 14, madam. Lordship, may kindly grant me a 3 weeks time to file my counter affidavit.
3 weeks time is granted to Mr.
And Kohima.
Edangami, Leonard Government Advocate,
No, madam.
to file affidavit in opposition. This is a matter after 3 weeks.
Thank you, madam.
Would you like to mention item number 27?
Yes.
It come up on 16.
Why?
20.
This is spoke.
Why?
Okay.
All right. On the prayer for adjournment made on behalf of the applicant's counsel, leaves the matter on 16. 16-2, na?
Small.
Yes.
In three. Worship, I'm for the petitioner.
Yeah, they don't.
I'll leave by my seniors Lima Obama. Yes, we will this today.
Any objection by the other side? On the prayer made for adjournment on behalf of Mr. Lima Wapang, learned counsel for the respondent.
For responding to the tree.
For the respondent in WPC 176 of 2019. For the petitioner, sorry. For the petitioner in WPC 176 of 2019, which is not objected to by the other side, list the matter after 2 weeks.
Mr. Lordship, I'd like to mention item number 25 and 26 here.
Yes.
Your state is yet to receive instruction, so kindly grant 2 weeks of time to plan.
Any objection?
My lords, I appear for the petitioner in 25 and 26.
Yeah, you are invisible.
1 second, my lords. Apologies. My lords, I appear for the petitioner in item 26. The respondent number 2 has not filed the reply yet, despite multiple opportunities. My lords, the matter has been going on for a very long time.
Number 2 and 3.
Yeah, then what is this matter about?
Lordship, it's behalf of my senior. So,
So what is, ask your senior what the matter is all about.
no. Alas.
My lords, a short date.
Since 2 weeks.
Last chance.
Lordship.
Otherwise, cost will be imposed upon you.
Lordship.
My lords, then last opportunity may be given
Yes,
and then next party hearing.
Mr.
Junior Lordship.
Learned counsel appearing on behalf of Mr.
Busy moment, Lordship.
B.Z. Momi, learned counsel for the respondent number 2 and 3
Lordship.
is granted one last chance to file affidavit in opposition.
My lords, a fixed date may be given. We
Given.
wish to come there and
Please the
argue the
matter.
matter.
When, which date?
My lords, anytime in March, whenever it's convenient for the court.
You tell me.
My lords, anytime in March would work. I have no specific date. We
Sunday,
wish to come there and
Sunday.
argue the matter.
March 16, Lordship.
March 16th.
No.
18 March.
March 16th. My lords, interim order may continue.
Interim order to continue till the next date.
Oblige, my lords.
Lordship, I beg to mention item 13. Lordship, I kindly grant me 3 weeks time to file my affidavit.
Ms. S. Mary is granted 3 weeks time to file affidavit for the state. List the matter after 3 weeks.
I take the motion item number 17. I'm yet to receive instruction. So 3 weeks time will be granted to me.
Lordship, it is emergency disposal because this is challenge of the seniority list of graduate teachers.
Emergency. What is not an emergency? Tell me.
Because promotional.
Yes, seniority issue.
Promotion and.
Right.
Withheld.
Yes, the council for the state and you for. Have you filed?
Yes,
You have filed.
Yes.
Okay. The state council is granted. How much time?
2 weeks time.
Will you file? Or is it for date for another adjournment or
No.
you will file?
Okay.
Have you received instructions or not?
No, not yet.
Okay, the state council is granted 3 weeks time to obtain instruction and file affidavit. This is the matter after 3 weeks.
Lordship, I beg to mention item number 24. The matter may be listed after 2 weeks.
Why?
As the senior leading counsel is on leave.
Yes, madam, what about this case?
Lordship, I have correspondence 6.
Who is the person, who is respondent number 6? Private respondent,
Ownership always come
who was appointed as Chokidar
on the ownership basis.
on land ownership basis. So you are also claiming land ownership basis.
Yes, Your Lordship.
And then she
Respondent number 6 is not based on their ownership.
it's appointment simpliciter.
Yes.
No advertisement.
No advertisement.
So that is what you want basically. Advertisement should be issued.
Actually, Your Lordship is for grade 4.
I know. Who had given the land?
The petitioner.
The petitioner.
Yes, sir.
Oh, the petitioner gave the land, not petitioner's grandfather or
The
something.
petitioner's great grandfather.
Ah. So you are not your great grandfather. So whether, as per the policy of the government, can there be reservation of a seat for all times to come, or of a post for all times to come on landowner basis? What does the government policy say?
According to the OM dated 5/3/2018, 2018 grade 4 post is mainly for the landowners.
Landowner, which landowner? The first landowner.
The first landowner.
That
Lordship, actually, the first landowner, he expired before completing his tenure.
so, but he was appointed.
He was appointed,
Then-
but unfortunately he died.
Then what about his son or
No,
daughter?
he's not married.
He's not married.
Yes.
Then how were you born?
I'm also one of the landowner. The petitioner is also one of the landowner, that's why.
Okay, different plots of lands were given. Is it? Or one plot of land was given? Given by who? How many people? That one plot of land belonged to how many people?
One great belonged to the petitioner's great grandfather.
Then he died. Then, so now, who is claiming?
The petitioner, the grandson.
But he did not have a wife, he did not have children. You are related to the you are the granddaughter. How come you are the granddaughter?
Grandson.
You are the grandson. That means through the father or through the mother?
Through the father.
Through the father. But the father, through the father. So your father was the son of the landowner
Yes, sir.
who was not married and who did not have children.
Yes, but then
Where's the logic?
in worship is actually the
Cousin or something. Nephew, you're the nephew of that landowner or something like that. No.
according to the pyramid.
No, it's like this. Look, you're the granddaughter. Then your father is there. Then your father's father. And then your father's father's father, great grandfather. But your great grandfather did not have a wife, did not have any.
The great grandfather, he had one.
He had a wife.
Yes.
Okay. He had a wife and he had children.
Yes.
And then your grandfather was one of the sons.
Was appointed on land ownership basis. He was not married at that time.
Okay. Then he got married.
No. He was appointed and he served 14 years.
Hmm.
And then while he was on service, he expired. So the next landowner, he applied the present petitioner, he applied.
The land belonged to 2-3 people.
No.
Can you someone enlighten me? You, madam? I'm not getting the gist, the connection. How are they related? How is the petitioner claiming land ownership basis? The appointment on land ownership basis. How?
The appointment is confined to the first appointment is only it's the
Correct, correct.
My or already is so
No case.
hearing the petition.
Yes, so your appointment was on the basis of an advertisement or not? Have you filed affidavit? Let us see your affidavit, give me. Yes, where is it? Twenty-three, 9/24. 23, 9/24. September 24. There's no case, madam. Affidavit or point number 6. They're 23, 9/24. Okay. Did you go through a selection process, madam?
No, Your Lordship, there was no selection process. But you would have stated in your additional affidavit, if I didn't want to fill, rule number 5.
Out of the blue, you said that.
Yes, Your Lordship, here we have stated here that the petitioner, they have already claimed on land ownership.
No, she has got no right. One thing I want to know is the OM of 2018, was it put to challenge earlier in some, and has it ever been put to challenge? Anyway, then now the thing is, you have challenged, you have not said that they were not selected through appointment process.
Yes.
You have not said that.
Well,
Where?
I mentioned.
Where? When were you appointed, madam? Yes, who's for the government? He's on leave. Why?
He's on bereavement.
Oh, he's in bereavement.
Yes, sir.
So was the selection done? We don't know. No selection done. Then your appointment is illegal, madam.
Your Lordship, we have mentioned.
Then your appointment is illegal. So what we can do is, we can, we'll dismiss the writ petition as there is nothing wrong with the OM of 2018. However, your appointment will also have to be set aside. In the meantime, a selection process can be carried out by the government, wherein advertisements can be called for from the general public until, which should be completed within a specified time. Until the same is done, you should be allowed to continue in your post.
Your Lordship, we have challenged 2018 OMs.
Maybe, but what is wrong? Challenge is there, but what is illegal about it? What is the illegality?
Your Lordship, we have also stated in our affidavit opposition in paragraph 7 that the lake where the department is situated, it has been donated by 6 villages comprising of 6 villages. And after that, my name was recommended proceeding on that.
Okay, your name was, you're one of the landowners also. And, okay. So it's slightly different.
And we have also.
And was anyone from your village appointed earlier?
The resolution we have annexed in our affidavit NHA.
Okay, so we'll adjourn the matter. You wanted to adjourn, no?
It's enough.
Correct. On the prayer for adjournment made. So that should be a point. Not that advertisement. You should say that the land belongs to 6 villages. Her family has been given appointment. We have not been given appointment. That should be your case. On the prayer for adjournment made on behalf of the Petitioners Council, this is the matter. After, Madam?
2
2
Another appeal commission, I move my hand. I said a draft copy of the final provision for waiting, so I'm not waiting for something.
Okay, right. Mr.
There's never recover after 2 weeks.
The state government council submits,
No, allow the CTC now.
the learned CGC submits that the draft affidavit
Yes.
has been sent for vetting
Yes,
and the same will be filed within 3 weeks. List the matter after 3 weeks. The matter pertains to non-payment of dues. Correct?
not the one is not very pleased, but this one is going regard to invalidation.
Okay.
Not.
The matter pertains to non-payment of invalid pension.
Yes, sure, okay. Dr. Reclamation Item 18, orders. Not given for the statement. That is follows.
So?
I prayed for 2 weeks time so that.
Mr. Counselor, this is the bid evaluation thing. It's everything is there in the record. You don't have to have affidavit. This is a contract matter that needs urgent disposal. You don't have to give anything. You just have to bring the record. When can you bring the record?
Yes. Lordship, I have a negotiation with the department, concerned department this morning, and decided that you will bring me the instructions tomorrow, on Monday only.
So you bring not only the instructions, you bring the records and the bid evaluation committee minutes. You bring that.
Correct.
That's all. Nothing else is required.
No, I'll be allowed to, let's report this for in the form of affidavit.
No. You bring the record, original records. Everything is there. You don't need affidavit. This is a waste of time. If you can place it within by Monday, the affidavit is okay. You're wasting time. This is an issue of contract.
Some issues are there. Your
Mr. Counsel, you are not above the bid evaluation committee. Whatever the bid evaluation committee says, you just have got to repeat it. That's all.
Right.
Then what are you going to say in the affidavit? Nothing. Whatever is there in the minutes of the bid evaluation committee, that's all. Then nothing is required. It's look, there's nothing to be very scared of in a contract matter. Contract matters, unless it is very patently illegal, it is more inclined towards development and the respondent, the author of the tender notice.
Yes.
Their judgments galore to the effect that courts cannot very easily interfere in contract matters. The only thing is that it should be. You see, what happens is there a stay here? Is there any stay?
Yes.
Look, there's a stay. If there's a stay, it is your duty to have it disposed of fast. Because the entire project cost of everything goes up. It's in your interest. Mr. Moimchen, the learned senior government advocate, submits that he will be given instructions on Monday. Accordingly, leave this matter on Tuesday. Whereupon Mr. Moy shall produce the official records, including the bid evaluation committee minutes, allowing rectification of the bids of some of the tenderers. List the matter also. Interim order to continue till the next day. You should be in a hurry to do it.
May I please Roshi, I beg to mention item 20 hearing item 20 on behalf of my senior citizen. Roshi, let the matter may be fixed on Tuesday 17th.
Why?
Roshi, my senior has some personal difficulties. It's a consensus prayer.
On the prayer made on behalf of Mr. Sentiagar, counsel for the petitioner, which is not objected to by the counsel for the state government. This is the matter on
Tuesday
Tuesday 17th.
Lordship, I beg to mention item number 21 on behalf of my senior Yamawati, earnest citizen. Lordship, my senior is in bereavement, so if this matter can come up on 19th February.
Okay. As it has been stated that Mr. Who is bereavement?
Yamawati, earnest citizen.
Yeah, it has been stated that Mr. Yangarwati CGC is under bereavement. This is the matter on
19th February.
19.
Next Tuesday.
One by one they have come, and at the end of the day there's hardly anything to do.
I didn't tell you about your family to some instruction. So
9 and 10. Okay. Miss Livika
yes,
is granted how much time?
2 weeks ago.
3 weeks time to obtain instructions and file affidavit. This is the matter of the 3 weeks.
Should I like to mention item number 50? The worship here we have instruction from the client to withdraw the petition.
Okay, they have been paid the bills. Probably bills have been paid, that's why.
If you may allow with liberty to file afresh.
Okay, right. Miss
Shisa Jabi.
Shisa Jamir, learned counsel for the petitioner, submits that she may be allowed to withdraw the writ petition with liberty to file afresh. Miss Hina Holly, learned counsel for the state respondents, submits that she has got no objection to the same. Accordingly, the writ petition is dismissed as withdrawn, comma, with liberty as straightforward.
Worship item number 6.
6. Yes.
Here we have received the affidavit in opposition filed by the state respondent. So if you may be granted time to file reply.
Worship, I'm presenting as we have got responding number 4, 5, and 7 to 32 worship. In the worship, we have to file our as well as
Item 6.
yes, item number 6.
What is your role? You're challenging their appointment or something? Yes.
I know the overall board have observed that there's nothing to do with the private respondent, it's only between the government and the petitioner. So we'll not be filing. Alright.
You will not be filing.
Yeah, because the local board has already observed that I have nothing to say.
I don't know. that is the risk you take. Miss Shisa Jamil, learned counsel for the petitioner, prays for how much time?
3 weeks.
3 weeks time to file reply affidavit to the affidavit filed by the respondent number 1, 2, and 3. Mr.
Brings over, I bring for private respondent number 26.
Perry for so 26 submits that he will not be filing any affidavit. Mr.
RCB motion.
RCB
Number 4, 5, and 7 to 32 motion.
4, 5, and 7, 232 submits that he will be filing affidavit within
3 weeks time.
3 weeks. 3 weeks time. At least the matter after 3 weeks.
For motion, item number 1.
Hello, I am appearing on behalf of the petitioner company. Now, on the last occasion, there was a question raised, which is fallen from my office regarding maintainability of this present petition in line of the facts. If I may take 5 minutes to just refresh the facts as to how I am entitled under Article 226 to approach minors. And see, one of my primary prayer in this petition is seeking a reinvestigation of a particular criminal investigation, wherein a final report has been submitted and it has already been accepted without taking cognizance by the learned CJM.
So you'll have to challenge the order of the CJM?
None.
If
We are not challenging the order of the CJM.
if you're not challenging the order of the CJM, what are you challenging?
We are seeking a reinvestigation. I'll show you my look first, if my lord gives me 2 minutes. Who are you? I am representing an insurance company. Where does the insurance company come into the picture? It is only when the claim is filed against the policy taken out by the relatives of the deceased or the nominee of the deceased. At that point of time.
No, you see, what I'm on, I understand. Your issue is that a policy was taken, a high policy,
Yes,
and he has died. And the death is not in dispute, I guess.
Death is not in dispute.
Death is not in
the
dispute.
nature of the investigation, which is ascertains it to be an accidental death.
That is what we are challenging.
That is what
Now what has happened is the final report made by the police has been accepted by the court. So a closure report has been given and which is accepted by the court.
It has been accepted.
Now,
no actions have been taken for.
No. Now, why don't you go to the same court?
My lord, I'll explain myself. My lord, as to who is involved, there is no statutory provision.
So there is no grounds for review in a criminal matter.
No. My lord, who has the locus to approach the magistrate at the time of the acceptance of the final report, which is submitted by the investigating authorities? My lord, as far as 2 judgments of the court is concerned, there is no statutory provision either under the earlier CRPC or the DNSS which deals with the right to protest, the procedure of protest, as to who can protest against the final report. But my lord, the 1985 judgment, Bhagwan Singh by Justice Bhagwati, what right and over 49 paragraph.
What about no copy for your learned friend?
Nobody has, there's no.
No notice. He's ready.
If he's ready, I'm ready to serve a copy.
Okay.
Paragraph 6. Paragraph 5. Well, this is the observation. But if I may read, the position may, however, be a little different when we consider the question whether the injured person or a relative of the deceased who is not the informant is entitled to notice when the report comes up for consideration by the magistrate. This is the final report which has been submitted by the investigating authorities. we cannot spell out either from the provisions of the Code of Criminal Procedure or from the principles of natural justice any obligation on the magistrate to issue notice to the injured person or to a relative of the deceased for providing such person an opportunity to be heard at the time of consideration of the report, unless such person is the informant who has lodged the first information report. But even if such person is not entitled to notice from the magistrate, he can appear before the magistrate and make his submissions when the report is being considered by the magistrate for the purpose of deciding what action he should take on the report. The injured person or any relative of the deceased who are not entitled to notice from the magistrate has locus to appear before the magistrate at the time of consideration of the report. Well, this is when the learned magistrate is considering the final report. Who has the locus? It has been defined that only the injured person, one of the injured person is no more deceased, or any relative of the deceased is to be present or given a notice, if at all, by the magistrate for hearing any kind of protest or concurrence with the final report before it is accepted and the final as a closure and an order is passed. My lord, I am at a place wherein this judgment has been followed. My lord, 2004.
No, you tell me, what is your grievance out here? What is the problem?
But I'll come to it. If I can first fairly establish who can be heard and whose locus it is to file a protest and get a protest being heard.
File a protest where?
Before the magistrate at the time.
Go and file. Is it your case? Is it your case that you can file a protest before the magistrate?
But I cannot file a protest before the magistrate. Then what is my alternative remedy? I have made a representation to the superintendent of police parent, bringing on record on the grounds on which there should be a reinvestigation. Now it is incumbent upon the SP at his discretion to approach the court for further investigation. Well, there is a difference between further investigation and reinvestigation. Further investigation under the earlier 173(8) and under 193(8) of the BNSS, the magistrate is empowered to order further investigation, even if he has not taken cognizance on the basis of a final report, if subsequent facts come before, but it is only through the investigating agency or any superior officer of that rank to approach the magistrate for further investigation. In respect of reinvestigation, there is a clear distinction that the magistrate has got no powers to order a reinvestigation. Reinvestigation can only be ordered by the Honorable High Court, either exercising power under Article 226 if those facts come forth regarding the locus of a person who is not an informant, not a relative of the deceased.
No, so why do you want a reinvestigation?
I am a life insurance company. When I am dealing with a high value claim, I have the right under the IRDA regulation, section rule 14 of the IRDA regulation. I am also a registered body where totally I have to report to the IRDA regarding whatever high value claims that have been disbursed. But once this claim comes forth, I am not in knowledge of the accident of the alleged investigation that has entailed, and thereafter the report. It is only after the final report has been accepted and all these with all these documents, the claim has been filed by the nominee of the deceased life insurer. Well, at that point of time, we embark on our internal investigation and we find the discrepancies which would show that if it is an accident case, crime officer, there has to be a postmortem done. Within 24 hours, an inquest has to be done by the executive magistrate or the district magistrate, whoever is available. Manoj, may kindly take up the report. Manoj, the FIU. Manoj, it is at page 24, but the complaint on the which the FIR is lodged is at page number 26. Manoj, this is the complaint which is lodged by the brother of the deceased mother. Well, if I may read, with due respect, I have the honor to inform your good office that on 18 January 2025, at around 10:10 p.m., my sister-in-law, that is the wife of the deceased, informed me that on 18/1/2025 at noon, my brother went to Parent District for business trip, and at around 10 p.m., she received a call from his husband's mobile phone, and the caller is supposed to be a good Samaritan. But it will kindly note, Good Samaritan informed her that the owner of this mobile phone has met an car accident at below Old Jalupia village, and besides that, the caller told her that he and his friend, while returning back from Parent Town towards Dimapur, after dropping one passenger at Parent Town on halfway at Old Jalupia Road, they approached near her husband's car from behind, and suddenly his car was rolled down highway. Therefore, they stopped on the spot and went down towards the spot of the fatal car rescue, pulled out the injured husband, and shifted to I Nursing Home and Diagnostic Center, Jalupia Town for medical first aid later. Well, at that point of time, the deceased was alive. This is when the first aid was administered. Later, concerned doctor referred and advised them to take the patient immediately to Dimapur for good equipment facility hospital at the doctor's advice. Well, there is a time gap between which the first medical aid at the first instance was administered. Then doctor might have a report that because of these injuries, particular injuries, which has been inflicted upon the deceased, the medical treatment at that particular nursing home could not be conducted, and hence you take it to another hospital which has got higher medical facilities. Well, there is not a scrap of paper or any doctor's advice wherein they were unable to provide that kind of medical treatment to the deceased. The deceased was alive at that point of time, so that there is a referral. Madam, I kindly take up the next line. We, the family members, are hereby requesting your authority to kindly investigate the matter from your end. Madam, this is on 18 January 2025 on the date of the accident. Madam, FIR lodged on 18 January 2025 at 10 o'clock. At one instance, the information is received at 7:30. FIR is getting lodged at 10. No anomaly in that. Well, thereafter, on that same day itself, the inquest has to be conducted within 24 hours. Well, the inquest is being conducted by the investigating officer. Well, as per 194, the inquest has to be conducted by the nearest executive magistrate or the district magistrate. Well, that is not done. This is one of the anomalies. Well, though it is technical in nature, and considering that the deceased was alive before being transported, the first informant, so the first witness is one Mr. Abdul Salam, who had spotted the site of the accident, pulled out the deceased, and took him to the nearest medical aid facility, which is the nursing home, and later shifted. And
what are you trying to get at?
Well, what I am trying to get at is, at the time of our internal investigation, all of these things, no postmortem conducted. Now, postmortem is absolutely mandatory in the nature of 196 PNSS. I'll quickly read the provision. 196. The magistrate or the executive magistrate or the police officer holding an inquiry on investigation under subsection 2 shall within 24 hours of the death of the person forward the body with a view to be examined to the nearest civil surgeon or other qualified medical person appointed in this behalf by the state government, unless it is not possible to do so for reasons to be recorded in writing. My lord, there is a request being made to avoid the postmortem by the complainant himself, the informant who has lodged the complaint on the basis of which the FIR is conducted, that may kindly take up page 30. Well, refusal of conducting PM examination. With due respect, Numbers, I have the honor to pray your esteemed authority to kindly hand over the body without conducting postmortem examination. Who is making this declaration? The declaration is.
You see, they're simple people. They think there's a motor accident, so they don't know the law. So how does it matter?
They don't know. The investigating officer knows the law.
Should know the law.
But the superior knows the law. Malad, thereafter, there is a belated affidavit.
So what are you saying? That he did not die due to a motor accident? Is that your case?
Without a proper investigation, how can that be established? Today, if there are certain riders in an insurance policy of a high value claim, my lord, may kindly take up the representation which we have submitted before the SP panel, my lord, which is that page number 4.
Yes.
My lord, firstly, income Mr.
Who is this person who died?
My lord, his name is Botovki Zimomi. Botovka Zimomi.
Yes, insured person is photocopy.
My lord, after going through our own investigation, my lord, what we have arrived at is at the time of the proposal, what happens in the proposal has been filed 6 months prior to the death.
So?
Eligible. Well, that might be the case. I'm not.
Naturally, just because 99 people of the persons don't die doesn't mean that 100 it should be 100%.
No, I'm not even getting into that presumption. Well, but at that point of time, his declared income at the proposal stage was 10 lakhs per annum. ITR filings for 22-23, 23-24 showed 2,52,000 per year. So the declaration in respect of the proposal and the income tax returns do not match.
No, Mr. Counsel, there can be an explanation to that. You see, it depends upon where his income is generated. If his income is generated in areas outside 1026, section 1026 of the Income Tax Act, then he will be liable for income tax. But if it is in areas within 1026, then, and he is a tribal and living in those areas and earning income from those areas, so those are not liable to tax.
Well, this is where it gets interesting. He states that he is having a real estate business. So that is not within the exemption of.
Why not? Why not?
Well, real estate income is capital gains.
No, sorry, you please do not, you see the Income Tax Act for these tribals in Mizoram, Nagaland, parts of Meghalaya,
exempted from
they are income tax. They may do any business.
I got it. Well, there were two high value policies during February and June 2024, which were applied, and already there are 2 crores and 1 crore from SBI Life and Tata. Well, banking activity also I'm not going into it. But kindly understand, if the cause of death presumptively accident, but if it was intoxication without preserving the viscera and that would have been examined in the postmortem state, there is no postmortem whatsoever. There is a rider in the policy under which we have to ascertain whether the cause of death. Well, we have also pointed out in our representation the rider to exclusion is alcohol or drug intoxication, self-inflicted injury, again without an investigation this cannot be ascertained, suicide or criminal activity. Well, circumstances surrounding the death was not properly investigated, and it was a very hastily provided report without a proper inquest.
Or is it that you do that is there? Maybe some conditions have not been fulfilled, but then how are you going to prove it otherwise? Now? Or do you mean to say that you've got no liability now.
No, but that is not what we are saying. We have kept it on hold. We have.
Why don't you deposit 50% of the amount
50% of the amount with whom?
in the registry of this court?
But I need to seek instructions. Well, if that is so, let there be a reinvestigation subject to deposit of 50%.
We will see, you bring that, if you get information with 50% of the amount, let it be deposited in the registry of this court.
Kept as a passable matter. I am just seeking instruction from the authorized officer of the company and well, if it is so that upon deposit there will be a reinvestigation, we are very ready and willing. I am just seeking instruction.
Yes, sir. You can ask, during that time you can go and ask. I'll
Your
listen to her.
Lordship, substance, this repetition is nothing but insurance dispute. And Your Lordship, the party is not an aggrieved party in the criminal investigation. So Your Lordship, because of a lack of locus, this repetition on that ground itself, it has to be dismissed, Your Lordship. And post-mortem could not be conducted due to the family request. So, no fundamental rights is valid. These are third party. Commercial disputes cannot be converted into a writ to control the investigation. That's my humble submission. This repetition is not a thing. Let's like.
Where is the citations?
I don't have a citation about it.
We'll say, so everything will be Miss Mere said. Miss Mere has held. No, it's a.
Well, may I place a judgment of the Gauhati High Court, Agartala bench, when it has been considered that insurance companies have the locus to maintain a rate petition under 226 for investigation. Well, paragraph 10. The petitioner insurance company, which is a public authority and state within the meaning of Article 12 of the Constitution, made necessary inquiry and on its own through its investigator unearthed the non-involvement of such and such. In the aforesaid fact, it is found to be true post the investigation. In that event, serious injustice could be made to accused if he is found guilty. That would also lead the petitioner company.
No, you see, out here, the petitioner insurance company had on its own inquiry had unearthed some facts. So where is your own inquiry?
Well, that is on our own inquiry basis we have filed the representation, my lord, with the SP. My lord, with the supplementary affidavit, the internal inquiry. My lord, as far as my maintainability is concerned, my lord, that is nipped in the bud that I have the right, or the petitioner insurance company has the right to maintain a petition under 226 for investigation.
You find out with your.
My lord, I'll take instruction. If my lord, we can deposit 50% of the claim amount with this court for the reinvestigation.
No, for deciding this petition.
Deciding this petition, then my lord, I have my recourse
to show that this is not a case for just escaping or your liability. To prove your bona fides. To prove your bona fides. We will not disburse the amount. We will ensure that it's not disbursed.
If I am unsuccessful in
then you have to pay.
Well, then it has to be refunded back to me because the claim has to be processed in a separate.
We will see that. You obtain instructions. Then we'll decide. Obtain instructions.
Well, I take the.
Oh, you wanted when? Today?
I'll just take instructions and come back. If I may be given the liberty to mention.
Sure. You just come and say that you are ready.
Well.
For motion, item number 2.
Yes.
It's not.
Yes, what to do, Mr. Angami?
If this may be issued, it's the
Why? You verify and pay. If it is you see, they have said that 8 lakhs, I think, is still to be paid. But how come 8 lakhs? Your calculation is not correct. It should be 8 lakhs something. That 30,000 or something you don't want. What? Can't it be done? You verify, and then if you find that it is an admitted amount, then you pay. The end of the matter. Why? Otherwise, they are going to come with a writ petition, affidavit, saying that either it's not admitted or partly admitted or something. You're going to say. So you do it now. That's all. Heard, Miss Ali Toshu, learned counsel for the petitioner, who submits that the petitioner successfully executed the internal electrification of the new SP office at Mokokchung under the work name of inverted commas construction of district command and control center at DEF Mokokchung under MOD 2015-2016 second floor and headroom bracket internal electrification inverted commas close comma for an amount of rupees 15,32,900. The work was successfully executed and completion certificate was issued by the concerned authority on 3/2/2022. Thereafter, the respondent authorities released rupees 7 lakhs to the petitioner as part payment in the year 2022. Pustam. As the next para, as the respondents failed to release the balance bill amount, the petitioner submitted a representation dated 24/9/2024. The SP Mokokchung wide letter dated 24/9/2024 addressed to the Director General of Police Nagaland stated that out of the total amount of rupees 15,32,900, a sum of rupees 7 lakhs had been paid to the petitioner, and the balance amount of rupees 8 lakhs was to be paid to the petitioner. The SP accordingly requested the DGP concerned for administrative approval and sanction for release of rupees 8 lakhs. As the respondent authorities did not pay the balance amount, the petitioner served a legal notice dated 11/12/2025 for release of the admitted pending bill amount of rupees 8 lakhs. However, the same has not been released to the petitioner as on date. The learned counsel for the petitioner submits that the writ petition can be disposed of if a direction is issued to the respondent authorities to verify the bills of the petitioner and to pay to the petitioner the admitted balance amount still payable to the petitioner. Next, Mr. N.V. K. Angami, learned senior government advocate for the respondent, submits that he has got no objection to the proposal made by the petitioner's counsel. Next para. In view of the consent of the parties, this petition is disposed of. Now, in view of the consent of the parties, the respondents are directed to verify the bills of the petitioner and to pay to the petitioner the admitted amount. The same should be done within a period of
4 months.
4 months from the date of receipt of a copy of this order. Madam, you should always make finance department a party. Money comes from finance department. Okay, right. Right in the thing, right in just after her submission, you just write. The learned counsel for the petitioner also prays that the secretary to the commissioner secretary to the government of Nagaland Finance Department should be implemented as respondent number 5. Full stop. On considering.
Finance Commission.
Don't say secretary, just say finance committee. On considering the prayer of the petitioners council, the commissioner to the government of Nagaland Finance Department is implemented as respondent number 5. The petitioner shall serve a corrected copy of the cost title to the registry of this court and to the council for the respondent. Then you make that, okay? His submission.
What request, if, in the sentence, verify and to pay, if it is payable.
Naturally, I said pay admitted amount. You pay the admitted amount. Admitted amount has to be paid. What do you mean payable? It has to be payable. Payable, what do you mean? It has to be paid. That is why we have made finance.
Usually there is during the process of verification some very total discrepancies.
So then you say that the admitted amount is this much.
Actually, we issued respondent number 2, EG for verification. Yes.
Okay, the verification should be done by the respondent number 2 and 3. DGP, the verification to be done by respondent number 2 and 3. The verification of the bills of the petitioner should be done by respondent number 2 and 3. Okay. Payable by all respondents.
For motion, item number 3.
Oh, today having a birthday. Heard so and so, okay. And this will be again for doing for successfully executing the internal electrification work pertaining to inverted commas, it is here in the synopsis. Construction of so till 2015, amounting to rupees 2,63,931. Then you write, the petitioner's counsel submits that despite completion certificate being issued by the respondent authorities. When was it issued, madam? Which year? When did you complete the work?
Hmm.
2020. Madam, 5 years have gone. Okay, whatever I said. Having been issued to the petition, the pending bill of the petitioner has not been paid till date. Even though legal notice dated 11/12/25 had been issued to the respondents, the same has also not been paid. The same as the said amount due amount has not been paid. Then that same finance commissioner, same thing, You just have to verify, and if you find that yes, she has to be paid, then you pay. If you find that no, she's not entitled to any amount, you just say she's not entitled to any. That's all.
For admission, item number 4.
Lordship,
Yes.
may I plead your lordship?
Yes.
Lordship, I'm appearing on behalf of the petitioner.
Yes.
Lordship, in the instant matter, it's my prayer is very short that since I am discharging the same duty as my previous substitute teacher was discharging. So, your lordship, the brief facts of the case is that
You want to be given the minimum scale of pay as per the permanent employees. That's all.
Lordship. That is my minimum prayer, your lordship.
That is your only prayer now.
Yes, lordship.
Because the other prayer you have already withdrawn. You are not pressing it.
Lordship.
There were 2 prayers earlier. One prayer you are not pressing.
Yes, lordship.
You are not pressing the regularization prayer.
Lordship.
Not equivalent with the permanent employees, but with the ad hoc contract employees. That is his rate.
With the other ad hoc employees.
Yes.
Who are getting minimum scale of pay.
Yes. Now the petitioner is to substitute.
Correct.
Yes. And the contention of the state is that this just a substitute, which is not required by
But you see, that person who he substituted, that person has left.
Yes.
So once that person has left, he's no more a substitute. A substitute is like this. Supposing he's working, he goes for leave, holiday. I go and work in his place. So then I'm a substitute for him. But once he goes and leaves that job, then that work, now I'm doing it fully. I'm not a substitute for anybody now. Only the name is substitute. But in reality, I am working as an ad hoc or temporary or whatever. That word substitute does not longer hold good.
The petitioner is on a fixed pay.
Correct. That's why he's relying upon Jagdish Singh.
Yes, and now and one other is there's the service conditions for of the education is guided by service rules.
So what?
And then there's no provisions in the service to the grant skill pay to this category of substitute teacher program.
You have to pay as long as you see the name does not matter. You can give him the name of Mr. Universe substitute teacher or Mr. Pluto teacher or whatever. That is not the issue. The issue is if he's doing a similar work as is being done by a permanent or ad hoc or whatever, and they're getting a pay scale, they're getting a higher pay, then you have to give that similar kind of pay to that person. Now out here, there's a pay scale. You have to give the minimum scale of pay, that's all.
He was appointed, and here again, a graduate teacher, minimum educational qualification is BA, BEd, and TET, teacher eligible test. The petitioner doesn't possess BEd again.
Then why are you using him as a teacher? If he doesn't have the qualification for being a teacher, why are you using his services? Release him.
Yes, so now the department is going to advertise the post.
Lordship.
You don't have, he says that you don't have the eligibility qualification.
Lordship, when I was appointed in the year 2012, the rules which are relying by the state respondents, that was not enforced during that time. It was
It's not a question of enforcement. If the rules are there, just because they have not followed the rules, does not mean that that gives you any right. A mistake committed does not confer any right to anybody.
Lordship, again, whether that my previous this name Aunok Tompang, whether he was possessing that same B.Ed qualification or not.
I don't know.
Why
You have to tell me.
Yes, he was also not possessing that same qualification, Your Lordship. In my reply to their affidavit in opposition, I have
You see one thing. Two wrongs don't make a right. Let us be very clear about that.
Lordship.
Two wrongs don't make a. The issue is if you are having all the requisite qualification, and if you are doing the job as is being done by a permanent employee or ad hoc or whatever, and getting a higher pay scale, higher pay than you, then you are having a right to claim the scale of pay that is being given to them. Provided you have all the qualifications as per the rules. Now, whether those persons, those permanent employees or ad hoc employees, whether they have all the qualifications. If they don't have qualifications like you, okay, maybe we'll direct, though it's on grounds of discrimination. But actually, as per law, if you don't have the qualifications, you should not be in service at all.
Yes, Lordship. So, Lordship, I'm in service for more, now it's almost 13 years, Your Lordship.
Yes, so those ad hoc persons, they've got all B.Ed degree, everything.
Yes.
Lordship, they have not placed on record anything regarding that.
Where is that statement made by you?
Yes, Lordship. Regarding Tompang Aunok, whether he had that B.Ed degree or not, they have not placed on record in their affidavit in opposition also. They have not placed anything on record that Mr. Tompang Aunok was possessing B.Ed degree. He was also graduate.
Page 4.
What have you said?
Page 4.
What have you said at page 4 without me reading?
Let's try the Nagaland education. Nagaland school education.
I see, I don't want the rules. You have already said the rules. I believe what you said.
Yes.
I want to know whether those persons in service, on the basis of which he is making a claim, do those persons have that qualification that you are about to read? Okay, right. We'll clarify this part. I cannot decide this issue unless you all bring out the facts, right? The petitioner's case is that he was appointed as a substitute teacher, substitute graduate teacher, in place of one Tongpang Aunok, whose services were subsequently terminated pursuant to a departmental proceeding. Next para. Though the petitioner in the present writ petition had initially prayed for regularization of his service and payment of regular pay scale at par with the other employees of the department, the petitioner has abandoned his prayer for regularization of his service. Thus, the only issue to be decided is whether the petitioner is entitled to be granted the regular scale of pay at par with other employees of the department. Next paragraph. Mr. K. Angami, the learned senior government advocate, submit that in terms of the recruitment rules, recruitment/service rules in force, graduate teachers are to have B.Ed
Yes.
degree, B.Ed degree
Yes, along with TET.
along with TET for appointment as a graduate teacher. However, the petitioner does not have the said qualification. He also submits that substitute teachers cannot be said to be at par with what?
The contract.
With a contract with persons who are working on contractual / ad hoc basis.
There's a notification. Sorry to interrupt, but there's a notification at one point of time, appointment of substitute were allowed to enable the teachers to undergo the necessary B.Ed degree, but by notification 2000.
And that's not an issue. Next. In terms of the judgment of the Supreme Court in the case of Jagjit Singh versus Union of India.
State of Punjab versus Jagjit Singh.
State of Punjab versus Jagjit Singh. Reported also, the petitioner should be granted the minimum scale of pay if the permanent employees of the department are being given a regular scale of pay. However, it has been stated by Mr. K. Angami that the petitioner does not have the required educational qualification for being a teacher, while all the other permanent employees of the department, while all the other contractual / ad hoc employees of the department have the required B.Ed degree and TET qualification. However, the submission made accordingly, the petitioner stands on a different footing than the others. Now, considering the submission made by Mr. K. Angami, he is granted 2 weeks' time to show that the other contractors / employees, what employees?
Lordship, ad hoc lordship.
Ad hoc employees.
Yes.
Are having TET / B.Ed degree. And is it true you don't have B.Ed degree and TET?
Lordship, is it? It's true, Lordship. Lordship, and one thing, Your Lordship, since I have been substituted in place of Mr. Tongpang Onok, so
the word substitution is just a nomenclature. It does not have any relevance to the issue at hand. Okay, you write one thing. The submission made by Mr. K. Angami regarding the petitioner being a substitute teacher is not relevant to the facts of this case, in as much as once Mr. Tompong Aunok had been terminated from service, the nomenclature of substituture is a misnomer. Becomes a misnomer. So you bring that, you see. This is the matter on
After 3 weeks.
3 weeks. You see, the problem is you don't have the qualification. That's the problem. Why? How can we? Yes, come.
Lordship, let the state respondent place on record that all the other ad hoc employees, they are also having.
He's going to do it. Correct. He's going to do it. Let him do it.
Yeah, Lordship.
If they don't have, then maybe.
Lordship. Obliged, Lordship.
Item number 1. I have already communicated with the legal officer who has attested and upon the affidavit in the current petition, he is going to relate the whatever the instruction has fallen from my order. It is going to take a little bit of time. But if this can be kept in another 2 to 3 weeks, because headquarters are in Bombay. And they are
Not 2 to 3 weeks, next week.
next week.
It's a short matter.
But if it is following from my order, that upon deposit, the investigation.
You cannot dictate what the court.
No, I am not.
We get the drift of what you're trying to say, but
Because in the event if I am not successful the writ petition, the company will be out of pocket without having the remedy to challenge it. And once my motion of challenge should not end by just the date of this.
you take a decision. Otherwise, we will give you 10 days time. We'll list it after today is what? Today is 12th. We can list it on 23rd February.
Well, if I am permitted to appear online because I am traveling from Calcutta.
There's no harm.
Great. 23rd.
On the petitions council is the matter on 23rd. On which date he submits that he will obtain instructions as to whether. No, forget that. It's 23rd.
Great.
For admission, item number 5.
Lord, and for the petitioner, and 83 petitioners stand before your lordship. And these petitions.
Land has been acquired. Land has been acquired.
Yeah, acquired, but my lord.
Compensation not paid.
Without any procedure as provided under the Constitution as well as under the statutory provisions. Not a single notification has been made. That is why all farmers, landowners are default. My lord, this petition deserves to be admitted and to be heard in court.
How? It's admitted.
10 times opportunity has been given to the opposite party respondent.
There's no filing affidavit.
There's no file. And on the 8th August, Justice Cole has given enough opportunity to the respondent.
Justice?
To reply. Justice Cole.
What?
Justice Cole. And
August.
Yeah, on August. On August.
Justice. August. Count. Okay.
And this was followed by, in the next hearing, Justice Kalyana Rice Sorana. He has given a clear, explaining elaborately in a judgment that respondents have been given the notice and they have received it. It is not a question that they have to appear in person. But then once it is proved that they are conscious of the writ petition lies against them, they are duty bound to reply. And letter from the NHI, it is very clear, it is on record, evidence is on record. They have asked the NHITC to appear on their behalf. It is their own record.
Who has requested NHIDCL to appear on their behalf?
And National Highway Authority of India.
He's going to.
They have already sent a letter.
To whom?
To the court as well as to the NHIDC. I don't know.
You said NHIDCL has sent a letter to NHIDCL. How can it be?
I don't know.
NHAI, you mean?
Yeah, NHI. National Highway Authority of India.
Have sent a letter to NHIDCL so that NHIDCL appears on their behalf.
But till now, even NHIDCL has done nothing. And in fact, even NHIDCL or NHI or central government has done nothing to because they don't have a ground to stand on their legs. Because everything has been direct. All the long procedures.
So just a minute. So the acquisition of land has been done.
Yeah.
Land has been acquired. Possession taken.
My lord.
Just answer my question.
Yeah.
Just answer my question. Has the land been used for widening the road?
Yes,
Finish.
it is good, no, 30, almost 30% is finished.
Okay.
And
So land has been acquired, there's no
construction is
notification.
going on,
And
construction is going on. And the landowners, they want to stop, but I said, no, let the court stop.
you make the award under the 2013 Act. End of the matter.
Your worship, I will allow to point out some. Here, actually, whatever project is undertaken by the Ministry of MOT, Ministry of Road and Transport. Now, implementing agencies energized. And when it comes to the state, PWD National Highway is the North Department.
Correct.
So none of the parties implemented here.
Oh.
And I'm facing a lot of problem because they have implemented chief secretary, that is an implication to the party. And now secretary, that's also by implication also. But local department is BWD National Highway. And Deputy Commissioner covers two districts. Deputy Commissioner Sinambutu and Mokshok. And they are also all implementing So none of the party, necessary party has implemented as a party in the responded. So we are also facing a lot of problem. Who will give the instruction? That is another thing. And my learned council has, in fact, the order dated, order passed sometime in there. Because when the principal respondent is not appraised before they come, why the petitioner pushing on me only? I only have solicited on the ground. So the order, of course, order is the same order. When the principal respondent is not responding to the notice issued by the honorable court. But since I'm appearing on behalf of the respondent, is the respondent?
Mr. Counsel, you have not made the necessary parties.
No, and
as respondent.
allow me to respond to his submissions. My Lord Council has appealed that Nagaland PWD is a party. No, my lord, there's a Supreme Court ruling on that.
This is number 6. Lecture 6.
Let me finish it.
I wrote the plan has completed by the chief engineer Nagaland.
Let me finish.
Let me finish. It's up to the petitioner. That is my account. And unless it is rectified, I'll be in a very tight position to obtain the instruction from the
Yes. My lord.
And
Mr. Counsel, I do not know why you want to argue a matter
Yeah.
on, technical matters. Issue, you see, how does it hurt you by impleading those persons? Because you see, there is a chance that their participation is necessary. We do not know what you see, the thing is that NHIDCL is a contractor. Okay, let's be very clear. NHIDCL is a contractor and NHIDCL subcontracts the work to the local contractors. And the supervising authority, not in all cases, but the supervising authority in some of the contract works done by the NHIDCL or the consultant is the PWD.
Yes.
Okay, so you have to make them parties. This is for your own
My
good.
lord, yes, my lord. I got it.
And then another thing is NHIDCL is not a party also here.
That's why. Let me finish it with his submissions. My lord, what you're saying, I understand. Now, this is a central project. They should have a authority of, central board. And as per seven share.
Mr. Counsel, this is not an issue of arguing on merits. This is an issue. You see, when we pass certain orders, they have to be complied with by the authorities. But supposing the order is aimed at NHIDCL, NHIDCL is not a party. How do then if they will say that NHIDCL has to do it, but then they are not a party, then what is their remedy? You have to file a fresh writ. No. Why waste time?
My lord,
you're not understanding.
It is for a contract.
This
is regarding the legislation.
Correct.
And then acquisition is done by the central government.
No.
Questions of a contract. That is the different issue.
I'm sorry, Mr. Counsel. Have you read the 2013 Act? Have you read the National Highways Act of 1956?
Yes,
Show me the provision which says that the award will be made by the central government. Show me the provision. Show me the provision which says that the central government will make the award. Yeah, you're just arguing for argument's sake. Show me the 2013 Act which says that the award, the compensation amount will be made by the central government. Show me that.
2013.
Naturally, correct. Or you want to use the 1894 Act, 1894 LA Act, then again, who is to make the...
That can't go competitions or compensation.
Now, who is going to make the award? My Mr. Counsel, please listen. Just now, what did you say? The award will be made by state government, payment will be made by center. I am not saying about who will make the payment. I am asking who will make the assessment, who will make the award.
First, the budget will be met by the central government.
This is the matter after 2 weeks. You're not understanding. No point. I'm not trying to argue with you, I'm trying to help you. But unless you make the necessary parties as respondents, my order will not be enforceable.
Section 3H of the National Highway.
Next case.
For admission, item number 7.
Yes.
Lordship, here we are yet to receive instruction, so kindly grant 3 weeks of time to file it.
Yes, madam, any objection? Mr. Ajumli, learned counsel for the state respondent is granted. How much time?
3 weeks.
3 weeks time to file affidavit in opposition. This is the matter of the 3 weeks.
For admission, item number 8.
Lordship, similar prayer.
8.
Lordship.
Same.
For admission, item number 12.
Here, I need to receive affidavit of opposition from the state respondents.
Yes. 12.
Lordship, she is on leave.
Who?
Lordship.
That's right. There is no affidavit in opposition filed by the state government. Accordingly, 2 weeks time is granted.
3 weeks.
3 weeks time is granted to the state respondents to file that affidavit. This is the matter after 3 weeks.
For orders, item number 16.
Judgment in written, judgment in person.
Yes.
Lordship, I pray before the Honorable Court that this judgment dated order 16/3/2022 is judgment in vain. Now, Lordship, here, part of the authorities of law, my Lord will kindly appreciate that we did not join the first page 435 because here the issue in the department was our salary 111, all from same appointment. We are not. I have the authority to cover. However, Lordship just outlined before this honorable court. 435 petitioners in the petition number 7.
No, you see, Madam.
Yes.
Let us, basic, I want to know what was the fixed pay amount. Let us be very clear. Fixed pay. 31,000?
31,350.
No, it's not 50. In the decisions passed, it is 315.
Oh, no. In the decision passed is our scale pay is 9,300.
To 34,800.
34,800 with grade pay of 4,200.
Okay, that is all right.
Yes.
4,000. It is not five. Now, when you look at the division bench judgment, it says grade pay of 5,400. Which one is the correct one?
Dear Miss. If my lord will kindly come to.
You come to the division bench judgment in para 2D. 2D.
It is in the notification 2D.
I want to be clear with that.
Okay, Lord.
Because different amounts are being shown. That earlier lawyer is old man. You should explain to him.
Lordship, is
That-
not much into practice, although.
He has to implead those persons.
I'm also saying, but he has. He has the other way of thinking.
Okay. Anyway.
Lordship. Lordship, my notification is, our case is, we will go by what the government fixation, whether there is any mistake in it. This will be annexure. Exemption creation of, yes, ours is C2.
How much is it? 5,400 or 4,200 grade pay?
Yes, Lordship. S3. That will clarify everything. Yes, it's true. The post creation grade grant. My lord, will kindly come to page 204.
Oh, just tell me, you tell me, that's all. I don't need to.
Yes, here. $9,300.
To 34,800. And grade pay?
Grade pay is 4,200 PM.
200. No, that's clear, no? Okay. 4200. Okay. So that is all right.
1 minute, Lordship, I beg your pardon. Here I have annexed all there are 5, so I'm just trying to 5 at the same time post creation of all similarly situated. Yes, 9,300. 900.
What?
Pay band is 5,200.
Huh? Pay band is 9,300 to 34,800.
Grade pay is 4,200.
Yes, okay, that's all. Now, what is the fixed pay they were getting? 31,300.
150.
No, but then look at the judgment of the single bench. What does it say? Earlier, when it was, you look at the judgment of the division bench at para 6D. They are like giving different judgments.
$31,350.
15, no?
Yes.
That's what you are giving all different numbers to us. So it's not 50. That's why because you said 50, we wrote 50. Just reading other judgments, all 15 here and 15.
This one.
Yeah, mistakes. Yeah. So you have to be very careful.
It is in my
So
bag.
that was reduced to 25,000.
Yes, for those first
purpose.
batch. And why our salary was not reduced is because there was one issue where the state government, the respondent government, those appointment orders that was issued by the state mission director, that was segregated and so the 435 where appointment order was issued by the state mission director. And why are 111 are subsequent appointees, our salary was not reduced to 25,000 is they said that since our appointment is issued by the Directorate of School Education.
Their appointment orders were issued by?
The first batch was issued by State Mission Director. State Mission Director. That is also under the School Education Department. However, there was that discrimination.
State Mission Director, and your appointment orders were issued by?
Director of School Education.
Only because of that?
Yes. That's why they...
But you all were all appointed against regular posts?
Regular posts. All post creation posts. So when the first batch approached this honorable court, they also alleged that out of same examination, same selection, 111 were not reduced to 25,000. So the present petitioners.
111. You are 111.
Yes, we are 111.
Out here, there's only 84, but.
Some resigned since it is a fixed pay. Some resigned. Some joined new jobs like that way. Now the only remaining have approached this honorable court. So that was the discrimination even amongst the similarly situated circumstances.
Actually, there is another thing that I find. You see, the division bench has not granted you the regular pay scale because you were appointed against regular post. It has granted you that regular pay scale only because whatever, the name may be anything. Only because you should be getting the same pay scale as has been given to those similarly situated persons that were working as what? That were
graduate teachers.
Those SSA and RMSA teachers. Not because you are appointed against a regular post. That was not the reason.
Here our contention is...
No, in the division bench.
Yes.
In the division bench.
It did not interfere with the regularization because we did not press for that. Because at the time when our...
No, Mr. You're not understanding the issue. In the division bench, the regular pay scale was directed to be given by the division bench because it said that similar persons were getting pay scale, so they should be given.
Yes.
It did not give regular pay scale because they were appointed against regular posts. Correct? Correct or not? Did you understand what I said?
Yes, Lordship.
So it was not because of that.
Here one aspect is those who were appointed by the Directorate of School Education similarly situated other teachers. While the case was pending, the previous case, writ petition 174 was pending, the state respondent took over similarly situated more than 1,000 over as state cadres
When?
in 2017. While the case is still pending.
No, but that case was of 2018. How can it be while the case was pending? 2017 of 2018. That is, so it cannot be in 2017.
2018, while the case was pending, Lordship. And
So then you had a right from 2018.
Exactly. Lordship.
Then why didn't you file a case?
Exactly, Lordship. But at that time, when we approached the court,
you did not approach the court.
The previous ones. The matter also, that's why I'm just confusing myself, Lordship. That's why at that time it was reduced to 25,000. So automatically, if we are given our post-creation pay band as a regular cadre, automatically we will become state cadre.
Now what I can gather from what you are saying
Lordship,
is there are two groups of persons who are appointed. One is by the state mission director.
Yes.
That is those persons who went to the Supreme Court.
Yes.
And then the other is the director of school education.
Yes, that's what.
Now in the director of school education, there was no reduction of their fixed pay.
Yes.
But there was reduction of the fixed pay of the state mission director.
Yes, exactly.
Now, but at the time, those persons had gone, say A had gone to this court by way of WPC 174 of 2018. That time, the government took over the services of all those persons who had been appointed by the Director of School Education.
Yes, Lordship.
Correct. But
as state
cadre, but not all, only some. They did not take over this writ petition.
Here it comes into batches. 2010 and 2013 batch. RMSA SSS teacher batch. They were taken over. And we were 2016 batch.
RMSA,
SSA. Then RMSA. Now it has been merged into Samagra.
2010.
10 and 2013.
2013 also they took over.
They took over.
And you were 2016.
We are 2016 cadre. So they left us out just because that we were appointed in 2016 and they did not include us in the state cadre. Though all are similarly situated, teaching in the same school.
But then you cannot claim, 2016 cadre. So they have not taken you as state cadre that time.
Yes.
So
neither now.
Now also you are not being taken.
Yes.
So you are going to be taken over as state cadre now only.
They have to. Now they will come up with a plea that.
So if they are going to take you over as state cadre, where is the order taking over this 2010 and 2013 RMSA SSA as state cadre? Where is that order?
That one I have not entered. Then next. Lordship will kindly. The petition is huge.
So unless your services are taken over, you cannot be given pay scale. But correct.
Lordship. They are still having the differentiation, but that will be they are differentiating us that we are to be paid scale pay, that post-creation payment. Whether they are taking us over the previous batch included, because the previous batch who went to Supreme Court and us, we now are all enjoying 31,315 at par.
But they are going to be given pay scale also.
We are not sure, but they are saying that they are.
It's going to be given pay scale. No, that is what the issue is about, I think.
Issue the first batch went to school for the cheaper.
First batch meaning that 174.
174.
They went to Supreme Court. They are going to be given pay scale. It's under process. So when they'll be given, we don't know. But they'll be given from the date of the order of the division bench, probably.
Yes.
From nature, it will be ordered.
So that is the issue here, and Lordship, since the 16/3/2022 judgment order of the division bench in writ appeal 9 that went to Supreme Court and got dismissed by the state government that filed SLP and review.
No, tell me one
we
thing.
have approached this honorable court prior to this. However, the law is
You have approached this court after the SLP was dismissed, but before the review. That's all. After the
that is it. And Lordship, here the question arises in other matters like petitioner they concealed our first post-creation payment. That's why we could not approach this honorable court. Now, Lordship, absolutely judgment in writ, the writ appeal 9/2022 judgment order is judgment in writ because and not in personam and covers the petitioner absolutely. And we are not fence sitters because fence sitters mostly refer to in matters of promotion, seniority, retirement, or pay fixation when those who are affected approach the court in delay and laches.
So it reflects it's with regard to pay. Pay is
yes,
sensitive.
pay is a continuous cause of action.
No, that's MC.
I have the citations, Lordship. I will satisfy my Lordship.
And another thing I just wanted to say is this RMSA, you are appointed under RMSA or under SSA?
RMSA.
Under RMSA, these ones.
Yes.
And those persons who had gone in the writ petition earlier, they were also under RMSA.
RMSA, Lordship.
RMSA. But the 2010-2013 cadre, they were taken over as state cadre.
Yes, they
in the
taken over,
state
taken over as state cadre.
But that issue the other
Anyway, that doesn't matter. How does that? So that just shows that everyone is not taken over. Unless they are taken over, they do not come into the cadre. That's it.
So that issue, I cannot comment as of now.
Lordship, the first one will be 2024 SCC online. SC 3662.
Yes.
14, 15, 23, 24.
My God. Miss Nivina is also getting prepared with her citation. She's getting prepared with her citation.
Very much, Lordship. Nevertheless, the law is very clear. Lordship.
Okay, let's see.
14, it says, it is well settled principle of law that where a citizen aggrieved by an action of the government, department has approached the court and obtained a declaration of law in his her favor. Others similarly situated ought to be extended the same benefit without the need for them to go to court. 15.
No, so that part is not denied. He also agreed. It's only from when?
Yes, that's what I'm covering that, Lordship. I have the citations, Lordship. All the benefits, Lordship. 15. in K.I. Shepard versus Union of India, 1987 for SCC 431. This court, while reinforcing the above principle held as under, the writ petition and the appeal must succeed. We set aside the impugned judgment of the single judge and division bench of the Kerala High Court and direct that each of the three transferee banks should take over the excluded employees on the same terms and condition of employment under the respective banking companies prior to amalgamation. The employees would be entitled to the benefit of continuity of service for all purposes, including salary and perks.
Madam, that we will have to read depending upon the facts and circumstances of that case.
Yes, yes.
You cannot just blindly follow a judgment. That will depend upon the facts and circumstances of each case.
2023. Lordship, I'm coming to that, Lordship. 23, paragraph 23. We hold that the appellant was wrongly excluded from consideration when other similarly situated officers were considered and granted permanent commission. Today, 11 years have elapsed. It will not be fair to subject her to the rigors of the 2013 parameters, as she is now nearly 45 years of age. There has been no fault on the part of the appellant, 24, on the peculiar facts of this case, and since nothing adverse has been replaced on record with regard to performance of the appellant in exercise of
Is there any other citation?
142 of
Yes,
the
any other citation? That's why I was.
Constitution. Here, the first judgment was implemented for children. This one.
No, I have seen that. Next.
2025. Next.
Give me all the judgments. Yes. Para?
Starting from paragraph 22. 23. Starting from 23, Lordship. In other words, the division bench could not have ignored the ratio of Nagendra Sani Chopra while stating it to have merely a persuasive value. Once it is established that the factual matrix is identical and the legal issue involved is the same, the principle of judicial discipline demands that similar relief be granted to similarly situated persons. 24. The next question is whether the writ petition filed by the appellant in the year 2005 suffered from delay in laches, having been instituted approximately 13 years after his appointment in the years 1992. It is well established that in matters involving pay scale, this is very relevant, involving pay scale parity based on removal of anomalies. The cause of action continues from month to month as long as the anomaly persists. Each month, when the employee receives lesser pay than his similarly situated counterparts, constitute a fresh cause of action. In M.R. Gupta versus Union of India, while adjudicating on the issue of whether claim of correct pay fixation was barred by delay and limitation, this court observed as follows. The tribunal misdirected itself when it treated the appellant's claim as one-time action, meaning thereby that it was not a continuing wrong based on a recurring cause of action. The claim to be paid the correct salary computed on the basis of proper pay fixation is a right which subsists during the entire tenure of service and can be exercised at the time of each payment of the salary, when the employee is entitled to salary computed correctly in accordance with the rules. This right of a government servant to be paid the correct salary throughout his tenure, according to computation made in accordance with the rules, is akin to the right of redemption, which is an incident of subsisting mortgage and subsists so long as the mortgage itself subsists, unless the equity of redemption is extinguished. It is settled that the right of redemption is of this kind. 25 Lordship. This is exactly the position of the petitioners. In the present case, Appellant filed writ petition before High Court praying for issuance of an appropriate writ to the respondent employer to grant him pay scale as genuine in place of anomaly in pay scale in partly and in other similarly situated persons. Therefore, the claim having a continuous cause of action, the plea of limitation or laches cannot be sustained in this case. 27, Lordship. Additionally, we also know that the respondent did not produce any material on record to show that the case of the present appellant is different from those with whom he seeks parity. Therefore, when other similarly situated employees have already been granted the benefit through judicial pronouncement, it would be grossly unjust to deny the same relief to the appellant. In conclusion, it further substantiated by judgment in Suprita Chandal Supra, where this court observed as thus 14. It is well settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. 28. The principle laid down in that similarly situated persons should be extended the benefit of judicial declaration without approaching the court individually finds full application in the present case. To avoid otherwise would be to encourage multiplicity of litigation and deny the beneficial effect of judicial pronouncement to those who are...
The facts here are different, Madam. You see, the issue is not with regard to whether you are entitled to the benefit provided to those persons. You are entitled, but from when? That is the issue.
That's why, Lordship. When a judicial pronouncement is already made and the petitioners have...
Now supposing, let us example. Supposing those first batch of writ petitioners supposing they had been granted the decision had been made in 2000, say, forget 2022, decided in 2000, and you approach this court in 25, after 25 years. Should you be given from that date?
No, that is not the...
No, I'm asking you.
Lordship.
How do you draw the boundary? Okay, from 5 years is too much, 10 years too much, 20 years is too much, 30 years too much. Where is the boundary?
Lordship, I just humbly pray before the Honorable Court that at the first instance here is our salary was not reduced. That's why we did not join them. That is first. And the first batch approached this Honorable Court on discrimination because now present salary was not reduced even among similarly situated persons. That is one aspect. The single judgment was passed on 5/2020. Now, Lordship, at the time when this first batch approached the Honorable Supreme Court, their salary was also at par with us, all of us, until this time, 31,315 at the time. So, this portion, and we were given legitimate expectation that when we approached the respondent government, they did not reduce our salary because we were appointed by the Directorate of School Education. That's why we will be given...
Give me the next judgment.
Lordship,
that's all, these two.
Here there are so many.
I've seen.
That I have.
Okay. Any other judgment?
2015 8 SCC.
How many judgments have you got?
Lordship.
How many judgments have you got?
Only 4.
My God.
The other one is...
Then Miss Jivika will have another...
2015 8 SCC submission.
Yes, which para?
For 37 and 38. I have, there are so many, but Lordship, I thought the first 2 SCC online will covers the whole. 37 says, Lordship, before parting with the case, we consider it opposite to state that this case remind us of the subtle observation made by MC Changla, CJ of the Bombay High Court in Firm Kularam Sitaram versus Dominion of India. The learned Chief Justice, in his distinctive style of writing held under SCC Online Bombay Para 19. We have often had occasion to say that when the state deals with citizen, it should not ordinarily rely on technicalities. And if the state is satisfied that the case of the citizen is a just one, even though legal deficiency may be open to it, it must act, as has been said by eminent judge, as honest person, keeping in view the stand taken by CCL and the manner in which they contested the case at all stages in different high courts and in this court by raising same pleas despite their education with this court lead us to draw the conclusion that untenable pleas were being raised by CCL just to defeat the legitimate claim of the citizens determined in their favor by this court in earlier litigations and which was known to CCL. Lordship, the last one is the one that Lordship has already pointed out, that is 2015-1 SCC, para 23.3. Let me just once come to this page 2015, 1 SCC. The other day that Lordship. Lordship, here in SCC 28/2020-2025, here also financial burden of the state should not override the honorable courts, the objective of the constitution.
Then in that case, you should be getting your regular scale of pay from the day you joined.
Exactly, that is also another aspect, Lordship. I was also.
If that is your case, but the division bench has not given you that.
Just let me read out 2023 one. Just here, if it is judgment in personam, Lordship, it is very clear. My Lord has
but then
also
but one thing you have got to say, you see, the Supreme Court in that Srivastava case has said that this exception may not apply. It does not say that this, it only says may not apply. It does not say that these exceptions will apply.
Lordship.
Or will not apply. It does not say, it says may not apply. So it can apply, it depends upon the court.
Lordship, yes. Lordship, I leave it to my Lordship judicious wisdom. However, in 23, let me read out only this paragraph, Lordship. I just want to satisfy my Lordship.
Yes.
However, 23.3, this exception may not apply. I'll read out, Lordship. In those cases where the judgment pronounced by the court was judgment in real, with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision, Lordship, I am just on this, decision touches upon the policy matter, like schemes of regularization and like CKC Sharma versus Union of India. On the other hand, if the judgment of the court was in personam, holding that benefit of the same judgment shall accrue to the parties before the court, and such an intention is stated expressly in the judgment, or it can be impliedly found out from the tenor and language of the judgment. Those who want to get the benefit of the said judgment extended to them shall have to satisfy their petition does not suffer from either laches and delay or acquiescence. Now, Lordship, here the judgment that 16/3/2022 has not specified that in respect of the petitioners only. Here the law is very clear. And so this is a judgment in vain. And this is with regard to my service already rendered, Lordship. And if I am to get, as my Lordship has proposed, obviously, if we go by law, we have to get from 2016 when we were appointed, because we concealed the post-creation payment and gave us the fixation. So if we are to go judiciously, Lordship, it is also there. And so our salary, we are still contesting. The other party is also still contesting. We have a right, we are entitled to get our post-creation payment. They did not give us, we are still contesting. So, Lordship.
Okay, let me hear. I think they have heard you,
Lordship,
Now you are going around the bush.
it's not about going around the motion, but we are in continuous service and agitating.
No. Basically, you are starting to repeat your argument. Yes,
This maybe.
I hope so.
Yes, Your Worship has actually instructed us to determine on the issue of judgment in the recommendation person, whether our case will fall on the. But before that, just one thing, Your Worship, if you can kind of come to paragraph
Page?
of the revision, page 12. Page 12 of the repetition, Your Worship, paragraph 1.
Page 12.
Yes.
Yes.
Lordship, let me just read out some of the relevant portion, Your Lordship. That 528 GT, that is 179, Your Lordship. Yes. And the petitioners, that is the present petitioner, jointly went for agitation for revocation of the OEM 2018. That is the reduction, Your Lordship. And representation was submitted to the respondent, but no action was taken. Meanwhile, the FRC corrigendum dated 5/2025 was surprisingly, Your Lordship, discovered by chance, showing that the 528 GT and the petitioners, who were appointed on 9/2/16 and on 2/5/2016 respectively, were appointed in the sanction post created by the state government in the payment of 9,334,800 with grade pay of 4,200. Now, Your Lordship, why I'm reading this is that, firstly, Your Lordship, the petitioner is saying they were not approved, Your Lordship, because their salary was not reduced. Now, when we come to the petition, what was the prayer? The prayer was for reduction as for payment, seeking payment. Now, the learned single judge granted that no, they should be given 31 because 25 is bigger and they should be given 31. But the prayer for payment was not conceded to, and therefore they went for appeal, Your Lordship, before the division bench. All along the petitioner, this group of petitioner, they were okay. The first prayer they were not aggrieved, Your Lordship. That shows the personal interest, Your Lordship, their rights, Your Lordship, individual rights. So they were aware of this, Your Lordship, but they didn't go. Why? Now let them explain why they were aware, but why they didn't.
They didn't.
Their skill pay, they were aware of this skill pay. They said that we should be getting. And because of that, only for that reason, it went for appeal. Otherwise, the reduction of pay was granted by the single judge, Your Lordship. It's very clear, Your Lordship. And because of no payment of scale or pay, then they went for division bench. Now, where were this group waiting? They should come from 2000 to from the point when they
got to know how the
yes, Your Lordship. And after that, what happened? It got granted. They were just sitting like that. We went for before the Supreme Court, we got dismissed. And the rest is the history, Your Lordship. So no, what
about their discrimination, even taking over the other similarly situated persons, as well as it is placed before this honorable court? We are.
Madam, she didn't disturb you while you were submitting. Yes, wait, your turn will come.
It's going in line with what my Lordship had given. This will not submitted, Your Lordship. So, your lordship, in that light, your lordship, if you see, they were just sitting, your lordship, they were conscious, they were aware, your lordship. So, as per the Irving case, they will definitely fall under the fancy to lordship. And now, coming to the fancy, there is an exception, as the Lord has also correctly pointed out. I have also made a study, your lordship, regarding the judgment in revenue, judgment in person. I would definitely, in my humble understanding of this, I would say that this judgment of the division bench will not be in rain. It is in person, my lordship. My humble submission, correct me, your lordship, correct me. It's my humble submission. Correct me, and your lordship, the facts is different, your lordship. Here, the facts entirely talks about the arbitration and talks about. But here, there's one underlying principles that the Supreme Court has given is about the difference between judgment in rem and judgment in person. The facts is entirely different, your lordship, and it has been passed in that line. But just the small principles which the lordship has actually decided about the judgment in rem and judgment in person. Judgment in Supreme Court, your lordship,
arbitration matter.
But just your lordship on paragraph 1, it said a judgment is a formal expression for deciding your lordship of conclusive adjudication of the right of livelihood. The judgment may operate in two ways. Your lordship, and here they are giving a definition. Paragraph 8, the first few lines will be it's a principle only, that's why I'm taking out only.
Yes.
Not the subject. A judgment in rem determines the status of a person or thing as distinct from the particular interest in it of a party to the litigation, and such a judgment is conclusive evidence for and against all persons, whether parties, privies, or strangers, or the matter actually decided. The lordship, such a judgment settles the destiny of the writ subject itself and binds all person claiming an interest in the property inconsistent with the judgment, even though pronounced in their absence. By contrast, a judgment and persona, although it may concern a risk, merely determines the rights of it. My humble submission here is that the lordship, there should, if it's a judgment in rem, it should be as stated, the lordship. A legal status should be. And if it's an infringement of Article 14 and striking out and all, it will apply, your lordship. If my understanding of the judgment in persona is that it's an individual right. And pay scale is an individual right. Unless there is a declaration, suppose the judgment says it's a declaration extending to all, then yes, it will be a judgment, even in service matters, your lordship. But if we see the operating portion of the judgment of the division bench, I don't find any that declaration stating that it will be extended to all covered by the notification, so and so. It's just that they're entitled to the lordship. Your lordship, my humble answer, correct me if I'm wrong, your lordship, because it's an interpretation of law, your lordship. However, lordship, my understanding is that it's purely personal interest. Their rights were not affected because of reduction, they didn't come, 1 point. But they were aware of the payment, your lordship, why didn't they come? That is one thing. Another thing is that it's an individual right, your lordship. And therefore, it's not public, your lordship. Really, it extends to all the public. It should benefit all, your lordship. That it settles, your lordship. It gives a legal status, your lordship. It settles. But when it comes to personal, it's to the individual rights. My understanding, my humble understanding. And therefore, your lordship, here if we see the judgment, the operative portion of the judgment, your lordship, of the division page, it only says this court holds that the petitioner are entitled for scale of payment of so and so. It's just specific, your lordship. It cannot be seen to be in rem. If it says the notification, as per the notification 2015, they should be getting, all should be getting, it extends. If there's a declaration, then your lordship, yes, I surrender. So your lordship, even if they're entitled, lordship, my humble submission, it should be prospective, it should not be prospective. Taking in the fact that there were fancy cases.
Anything else?
So, your lordship, whichever perspective, if this lordship deems that it should be given, then if they're entitled, then it should be prospective. What retrospective to the debt, taking into this. Difference between the judgment and written judgment and in person. If I have correctly interpreted the. So your lordship.
If so to say. Lordship, because this involves, it will have, it will have a.
It should not be, it should not be up to.
It will have some, it will have some effect on your fees or.
No.
Anyway, you see, the thing is that, we'll see, now I basically have heard. You want me to hear you some more? How much?
Just to counter her interpretation, if it is judgment in personam, normally, as my lordship is well conversant with, it will say only in respect of, the other day also, only in respect of the petitioners are always, when it is judgment in personal, it is always stated. Just my humble submission, I won't submit any more. Just this paragraph 2025, just it covers whatever have been left out, lordship. Just let me, before this honorable court, let me read out this. SCC online, SC 28020. Even in the previous one, also the last conclusion part, portion, those are the authorities of lordship. Just 29, I will leave out everything. I have about 10 paragraphs, but lordship, just 29. Paragraph 29.
Yes.
And conclusion portion only. Just my humble submission.
Please.
Yes, lordship. The division bench, in our considered view, erred in failing to appreciate the binding nature of Nagendra Sahib Supra judgment on identical place employees, while also erroneously applying the doctrine of delay in wages to a continuing cause of action. Moreover, it gave undue weightage to financial consideration while ignoring constitutional principles and failed to examine the merit of the case and the recommendation of various committees that had acknowledged the anomalies. The judgment of the learned single judge, on the other hand, correctly applied the ratio of Nagendra Sahani Supra to the appellant's case and granted appropriate relief. The division bench interfered with such well-reasoned judgment was unwarranted and legally unsustainable. Conclusion. 30. In view of the foregoing details discussion, we are of the considered opinion that the principle of equality enshrined in Article 14 of the Constitution of India brooks no discrimination between persons who are similarly situated, and any differential treatment must be based on intelligible differentia having
the issue is basically this. There's no denial of the fact that you are entitled to pay scale. The only issue is whether you're entitled in terms of the judgment passed in the division bench with the appellant. Now, if it was a judgment which was in rem, why shouldn't you have been given the pay scale from 2016?
Exactly, Lordship.
So if it is not a judgment in rem, what is it?
That was not the subject matter of the first case.
So if it is not agitated, so whose fault is it?
That can be agitated, but before.
Now that judgment has attained finality with the SLP and the review petition being dismissed.
Right.
That judgment is final now.
That is final. That's why I will leave it aside, Lordship. However, I am saying that we are in service. We are still in service. We were rendering service since 2000.
I think I've heard, madam. I think.
Lordship.
Otherwise, we're never going to
say. This yesterday's notification that was placed before this honorable court, Lordship. The last portion. That
Tata thing, the Tata case. The person who had come, the Tata case, that item 1. I put it item.
The last
Okay.
paragraph 32 maybe read out, look into Lordship. This one, the one I am reading. This is again.
I'll look.
Because this honorable court judgment will, Lordship, will affect the whole service career of the petitioners.
No. You see, one thing can always be given. Notional benefit can always be given. In terms, and the actual payment can always be given separately. Notional payment, because for the purpose of increment and all everything, can be given as is being given to the appellants in 9 of 2020. But actual payment can be given separate also. Let's see. Let me take a decision.
Yes, Lordship.
Heard says so.
My case also may be considered because it is the authority.
I'll consider both of your cases and I'll take a decision which you all will have all the right to go in appeal also.
Minimum of 6 months at least.
Huh?
A minimum of 6 months at least.
Time limit. I would not say time limit. Just right. Heard says so. Hearing concluded, judgment reserved. I think judgment has to be reserved. Because we all have brought out an issue which I'll have to just consider a little bit.
I have so many suggestions, Lordship.
I know, that's why I'm taking time. I cannot finish.
And you could say it's going to be disposed, otherwise this one, the last paragraph ought to have been under challenge from the petitioner side. However, they have not filed any affidavit in opposition otherwise.
What challenge?
The one stating that in view of the above said, they have already admitted.
Correct.
It's an admitted.
That is only a request. That is not the law.
It's not the law, but these things works here in the city.
No. That is neither here nor there. I have reflected it in the order. I'll put it in the order. Not a problem.
We have one more matter.
Oh, one more matter. At two. Okay, you're there. Okay. We'll do it. Yes, come. Item number? Okay, this item yes. Yes, who is there? Livika, you're there, item 19. I know,
Item 19.
19, yes. Ms. Livika, this is that matter where the government has said that the order passed in WPC 221 of 2019 was obtained by fraud. He was a police person, I think, something. And then...
it's not that. Item 19 is...
Item 19 is an application for... whose case is it, madam?
It's not mine, but still is mine.
Yes, still, who is the counsel? So we'll take it up at 2. You tell the counsel at 2 o'clock. had appeared for the parties on call. This application has been filed praying for a recall of the order dated 29/11/2022, passed in WPC 221/2019, on the ground that the same had been obtained by the writ petitioner by playing of fraud and misleading this court. The writ petitioner had apparently submitted a forged certificate in respect of her late husband, showing that he had passed away on 10/7/2011. No. He had passed away on 28/1/2008, though he had actually passed away on 10/7/2011. Full stop. What to do? Not coming for 2 consecutive times. They dismiss it for default. It's the logic. It's not done. They should at least right. As no one appears for the applicants on 2 consecutive dates without applicants, that is the state of Nagaland, on 2 consecutive days, it appears that the applicants are not interested in pursuing this matter. The application is accordingly dismissed for non-prosecution.
Consider